Lil Durk lawyers try to sneak this one in, and I found out the play that they doing. So here we go. Defendant Durbank's motion to dismiss count 2 of the fourth superseding indictment. And that's scheduled for the 18th, which is, I believe, Tuesday. We might do a pop-up. I don't know yet. Still debating. So it talks about count 2 of the fourth superseding indictment, and it should be dismissed for 2 reasons. The first is that it fails to state an offense, Federal Rules of Criminal Procedure 12B3BV. Specifically, it fails to allege the mens rea necessary for a conspiracy to violate the stalking statute 18 U.S.C. 2261A, namely specific intent to harm a particular person, United States versus Schrader. And then it goes on to say it is an element of the stalking statute to intend harm to a particular victim. United States versus Fiola. To be guilty of a conspiracy, a defendant must possess at least a degree of criminal intent necessary for the substantive offense itself. Second, count 2 should be dismissed because it is duplicitous, joining 2 or more offenses in the same indictment, Federal Rules of Criminal Procedure 12B3B1. The indictment alleges 2 individuals, TB and SR, who were the subjects of the alleged conduct. Oh. Yeah, because then you can slick say, well, everybody in the car technically would be up under that because it wasn't just Lil Pop and Quando Rondo. Just putting that out there, you know what I mean? Procedural background. The third superseding indictment, count 2 in its current iteration, first appeared in the third superseding indictment, which was filed on June 3rd, 2026, docket number 423 at 1222. The count accuses Mr. Banks and all defendants of violating 18 U.S.C. 371 by conspiring to violate 18 U.S.C. 2261A2AB. It alleges that the object of the conspiracy was the following: beginning on a date unknown, but no later than around November 6, 2020, and continuing to at least around August 2023. The defendants conspired and agreed with each other with the intent to kill, injure, harass, intimidate, and place under surveillance with the intent to kill, injure, harass, and intimidate, that looks like in or her, but that's that damn watermark that Dirk Daily is doing that's messed me up. Anyways, another person used facilities of interstate and foreign commerce to engage in a course of conduct that would place such person in reasonable fear of death and serious bodily injury, and would attempt to cause, and would be reasonably expected to cause substantial emotional distress to that person. And once again, this goes to how weak this case is. They're throwing them both in, meaning throwing Lil Pop and Quando Rondo both in as a stalking charge so that the jury just sit back and they go, oh, well, shoot, yeah, maybe he agreed to stalk Quando Rondo. Maybe he agreed to stalk Lil Pop. So we're just going to basically say that this is all one stalking charge. So they're basically looking at this. This is how Drew and Brian and Marissa and everybody are looking at it. Bro, if you're going to say that he stalked somebody, say the other person's name. Because if you don't, you got to prove it. And that's the sneaky shit. Not in a negative way. Don't think what I'm saying is sneaky in a negative way. I mean, like, nah, bro, y'all not finna slick this shit in here. But let's continue on. Roll it. Docket number 423 at 12, emphasis added. The indictment goes on to allege in some detail the means by which the object of the conspiracy was to be accomplished and overt acts in furtherance of the conspiracy. The third superseding also included as count 3 a substantive stalking charge. This court alleged that more than 2 individuals, including 2 who were alleged by name, TB and SR, were the intended object of the stalking. Then it goes on to say alleging specific intent vis-a-vis TB and others inside of TB's vehicle, including SR, the victims. The fourth superseding indictment. The fourth superseding indictment was filed on July 31st, 2026. According to the government's accompanying notice, it was filed to address a potential duplicity issue in count 3 of the TSI, docket number 515. The notice explains as the government was preparing its pretrial filings, including proposed jury instructions, it determined that count 3 as alleged in the TSI was substantive 18 U.S.C. 2261A2A. B count potentially presented a duplicity issue given that multiple victims were alleged in the same count. Holding that the victim is the unit of a prosecution for violation of that law, finding stalking charge duplicitous and ordering government to proceed as to only one victim. The notice explains that in order to cure any such issue, the fourth superseding separates the substantive stalking count into two separate counts, one aimed at TB and the other aimed at SR. Count 2, however, remained the same from the third superseding to the fourth superseding. In particular, the object of the conspiracy section does not name a particular individual who is this object of the defendant's intent. It only says that the defendants conspired with the intent to take legal action against another person. So before they try to mix them in as one, I believe that's in the second superseding indictment. And since the law doesn't allow you to do that, you can't mix them both because the stalking charge has to be individually. They're putting in the second one, but they're leaving it as an unknown, which will confuse the jurors. This is how they're presenting it. It'll confuse the jurors, and the jurors won't know who. So they could think that he was stalking the unknown person and directly contribute or attribute that to Lil Durk. And that's a huge ass problem because once you decide to say that these are the victims, you know what you had to do in court, right? Gotta prove it. Legal framework and argument, a timing of the motion. Rule 12B3 of the Federal Rules of Criminal Procedure outlines the pretrial motions that must be made before trial if the basis of the motion is then reasonably available and the motion can be determined without a trial on the merits. Among them are a motion alleging that two or more offenses have been joined in the same count, duplicity, and a motion for failure to state the offense, Federal Rules of Criminal Procedure 12B3B15. The rule permits a court to set a deadline for the filing of such motions. The court may, at the arraignment or as soon afterward as practicable, set a deadline for the parties to make pretrial motions and may also schedule a motion hearing. If the court does not set one, the deadline is the start of the trial. For the Rules of Criminal Procedure 12B4, in this case, the court set a pretrial motions deadlines that were key to previous trial dates, and hearings on those motions were held in February of 2026. However, the count that is the subject of this motion was first filed in the third superseding indictment on June 3rd, 2026. Well, after the pretrial motions deadline passed, Mr. Banks files this instant motion approximately 6 weeks after the third superseding motion was filed and before trial in this matter. This motion is either timely or the timelessness should be excused for good cause. Count 2 fails to state an offense. Count 2 fails to state an offense. A conspiracy to commit a substantive offense cannot exist without at least the degree of criminal intent necessary for the substantive. It is an element of 18 U.S.C. 2261A, the stalking statute, that a defendant intends to harm a particular person. The statute unambiguously, sorry, I just butchered the hell out of that, requires that the defendant act with the intent towards a particular person. Therefore, it is an essential element of the conspiracy to commit stalking under 2261A that the defendant intends to harm a particular person. The fourth superseding fails to allege that Mr. Banks had the intent to harm a particular victim. Therefore, it fails to state an offense. Count 2 is duplicitous. An indictment is considered duplicitous when a single count joins two or more distinct and separate offenses. The prohibition against duplicity is intended to safeguard fundamental constitutional protections, including a defendant's Sixth Amendment right to be informed of the nature of the charges and the Fifth Amendment protections against double jeopardy. A general verdict of guilty on a duplicitous count can breach the defendant's Sixth Amendment rights because a jury could find the defendant guilty without reaching a unanimous consensus on the commission of any single particular offense. Such a guilty verdict would prejudice a defendant's ability to assert a double jeopardy defense in subsequent prosecutions, and it creates prejudice during sentencing when seeking appellate review. Focusing now on count 2's atticus reus and not its mens rea, the charge suffers from the same duplicity problem that caused the government to file the fourth superseding indictment. That is, it describes an alleged course of conduct directed at more than one person. I was going to read that note, but it ain't really nothing from what I'm seeing, so we'll leave that be what it is. Indeed, the government's proposed jury instruction on count 2 names no alleged victim at all. Docket number 566 at 14. This creates a danger that a jury could find a defendant guilty without reaching a unanimous consensus on the commission of any single particular offense. In other words, a jury could convict if someone could believe that the defendant stalked TB and some believe that they stalked SR. Conclusion: for the reasons set forth above, Mr. Banks respectfully requests that the court dismiss count 2 of the Fourth Superseding Indictment under Federal Rule of Criminal Procedure 12B3B1 and 5. So the feds are essentially saying it this way. Oh, we fixed number 2 by saying it wasn't just Lil Durk. It was actually, not Lil Durk, but it wasn't just Quando Rondo, it was Lil Pop as well. Right. But the law doesn't allow that. See, you had to prove the stalking charge per the person, because if it was actually truly Lil Pop freaking being stalked, you would have a history of Lil Pop being shot at by OTF members and all this crap and everything. Nobody, no disrespect to him, but nobody knew nothing about Lil Pop before he got killed. Now, his people, obviously, and he does mean something to someone even in his death. I'm not saying that. What I'm saying is this. The fact that they're bringing him in as a stalking victim, but not saying it, is only trying to make the jurors sit back and go, hey, man, so the guy who died, he was stalked, but we don't really have a name, so I guess it's going to be the Lil Durk guy. See, if they were to find stalking for Lil Pop and they don't find stalking for Lil Durk, how the hell did they find stalking for Lil Pop? You got to put his name in there. And I think that's what the judge ultimately does. I think that's the sneaky move that they're trying to do, in my opinion, because the judge isn't going to dismiss this. If he does, I'm going to be like this. Oh, shit. Because we all know it's literally written for what it is, and nobody wants to say it out loud. The feds don't give a damn about a murder for hire charge on Lil Durk. And I swear to goodness, once you guys see this shit, you have the 35 witnesses, but 20 substantive witnesses and all of this shit. And you're never going to hear about actual money being placed for people to get whacked, because it literally destroys the damn Chicago indictment that says, hey, bruh, he got paid, these 2 dudes got paid, and all of this shit. Why would you pay these fools? Why? Why? But you ain't gonna pay the dudes that's right next to you? That I know, if they are alleged to be shooters and killers and all of this stuff, why ain't they pop your ass? We don't know who the hell hit his house. We don't know if it was some quote unquote ops. We don't know if it was his homeboy. We don't know shit. Then they used the phone shit, only got 4 screenshots. And I told y'all, there is no proof of who actually was the person to give the screenshot. You have zero idea if Lil Durk was the one who took the screenshot, or that goddamn somebody just sent it to him. I got a homeboy right now. All he do is send me memes of shit. He do this shit like 5 times a day. I can't keep up with all this shit. But if the feds were to accuse me of being a goddamn meme reader, not that that's a charge or anything, you know what they would do is they would hit my phone and then they go, oh, look at all these damn memes. And my lawyers would argue, hey, did Seti Nash ever ask for a meme? No. Did Seti Nash ever send a meme back? No. So would it be fair to say that his homeboy was just sending him this shit? Yeah. Y'all remember this real well in case you forget it. And I get it. But it's going to be in the end And it's going to be in the beginning as far as arguments go. The feds have to prove this shit beyond a reasonable doubt. Just getting messages is not enough. Now, I get it. Some of y'all are on this train of Seti Nash is a Lil Durk, whatever, OTF, whatever. Man, let me tell you something. Ain't nobody paid me a dime. Y'all used to say, yo, Seti Nash is a NBA Youngboy and Quando Rondo channel and all of this shit. Now it's Seti Nash is a damn Lil Durk fan. It's none of this shit. I just don't believe that the feds made their case. That's it. If you disagree, disagree. It's fine. But to believe some of this shit that y'all saying, nigga, do you know how much money I'll be charging to goddamn spread propaganda? Do you know my price? I don't think y'all know my price. If somebody were to pay Seti Nash to goddamn run propaganda, I think I would do it better than the way I'm doing it. Just being honest. Because I would ask you the question, how much is it worth? How much? Because I think to my goddamn self, I need to be paid like Drew, like Brian, like all them. You may have paid whatever, and whomever and ever according to the feds, but the Seti Nash payment, that bitch high. You heard me? So nah, I'm not being paid. It's just y'all can't convince me to go with shit I don't believe. If you disagree, it's fine. But I've watched countless witnesses in the Young Thug trial come up and all this shit and everything. And you know what the feds have not alleged yet? Oh, this goddamn witness says he was paid. That hasn't popped up anywhere. Can any of y'all show me where it says the person was paid? Oh, you can't. All you can go off of is what a lying ass witness said about them being paid and goddamn in and out. Then the feds got the tape and realized there wasn't no goddamn paid anything for in and out. So what are we doing here? Anyways, if y'all can, man, be a good friend, hit that like button. Shit, I'm getting like 200-300 likes of these videos, bro. Then force this to the algorithm, or I can't go to the trial, bro. I'm just gonna be honest. Y'all like the other shit. Don't get me wrong. Y'all like the other shit, but the Lil Durk videos, bro, we need the like button up on this one, man, or we can't go to the fucking trial because I'm about to waste my shit and spend my money on some shit y'all basically falling off and slacking on. No disrespect, but I can still get my scratch being right here and just reading the transcripts instead of popping up. Gotta make logical sense. And I ain't no nigga that's finna get on here and beg y'all for shit. Might put my Cash App up, but that's on y'all. All we need is just hit the like button. That's shit. Other than that, subscribe, turn the bell to notify, and share to keep your people alive. I'll catch y'all in the next one. Blueface, Christian Rock, what the hell going on? Click right here for that video or click right here for the playlist, and I will catch y'all in the next one. Y'all come on back now, yeah?